本日はお忙しい中、英国 EU 離脱と商標、ブランドオーナーは何をすべきかのウェビナーにご参加いただき、誠にありがとうございます。司会を務めさせていただく加藤です。私はマークス&クラークで科学に特化した弁理士として働いております。本日はウェビナーの最後に Q&A セッションを設けておりますので、レクチャーの途中、休憩中、もしくはレクチャー後にご質問がある方は Q&A ボックスに日本語か英語で質問をご投稿ください。当ウェビナーは日本語の同時通訳を用意しております。日本語でご視聴いただく場合は、右下の地球のようなアイコンにカーセルを持っていっていただくと、日本語、英語の選択肢が出てきます。日本語を選択すると日本語で、英語を選択すると英語でウェビナーをご視聴いただけます。本日は3つのパートに分けてレクチャーをご提供いたします。各レクチャー後に数分の休憩時間を設けております。パート1、離脱後の EU、英国における商標の動向。パート2、EU と英国における異議申し立て制度の違い。パート3、関税措置の確認。ここからは英語で司会を進行させていただきます。I would now like to introduce the speakers who will be giving the presentations today. First, we have Mr. Tom Farrand. Tom, please can you give a brief introduction?
Good morning. My name is Tom Farrand. I am a UK trademark attorney and I am head of the trademarks practice at Marks & Clark in the UK and Europe.
Next, we have Ms. Kirsten Gilbert. Kirsten, please can you briefly introduce yourself?
Hello, my name's Kirsten Gilbert. I'm a solicitor and I'm head of the trademark dispute resolution team for Marks & Clark in the UK. And I have over 20 years experience of enforcing trademarks in the UK and the EU.
Thank you, Kirsten. Next, we have Mr. Jason Chester. Jason, please can you briefly introduce yourself?
Thank you, Yumi. Good evening, everyone. My name is Jason Chester. I'm a senior associate and a chartered trademark attorney based in our Edinburgh office. I've been part of the Japan team since joining Marks & Clark in 2013.
Next, we have Miss Eve Brown. Eve, please can you briefly introduce yourself?
Hello everyone, I'm Eve Brown and I'm an associate and chartered trademark attorney that's based in the London office. I've been at Marks & Clark since 2017 and I've been assisting Japanese clients with trademark matters since then.
Thank you, Eve. Finally, we have Mr. Eric Rook. Eric, please can you briefly introduce yourself?
Thank you. Good evening, everyone. I am Eric Rook. I'm a chartered UK trademark attorney and European trademark attorney based in the Luxembourg office for Marks & Clark.
Thank you, Eric. That concludes the introduction, and therefore I will now hand over to Jason and Tom to start the first presentation.
Thank you, Yumi. Here are the contents of the first presentation. Next slide, please, Jason. Here we have a quick reminder of how we reached this point. An unexpected result in the 2016 referendum when the UK voted to leave the European Union. It created a period of major political upheaval, starting with the resignation of the Prime Minister immediately afterwards. A general election in 2017, when the government lost its parliamentary majority and Article 50 of the EU Treaty was triggered, beginning the 2-year withdrawal process. Negotiations began with the EU on withdrawal terms. Part of this was the UK government's early guarantee to protect IP rights already registered under EU regulations, for example, EU trademarks. The mechanism chosen was to create comparable, often called cloned rights, effective in the UK after withdrawal. In 2019, the UK government was unable to reach an agreement with the EU and gain approval from the UK government. The withdrawal date was extended as a result. Another Prime Minister resigns. Eventually, a general election was held and the Conservatives under Boris Johnson were re-elected with a working majority and a mandate to withdraw on 31st January 2020. This was approved by Parliament and we entered the transition period, which ended on 31st December 2020. From 1st January 2021, the UK is outside the European Union, the single market, and the customs union. The end of the transition period has created some significant changes to the landscape of trademark and design rights in both the UK and the EU. Over to you, Jason.
Thank you, Tom. There has been a significant growth in the volume of UK and EU trademark applications filed between 2016 and 2021. 65,710 UK trademark applications were filed in 2016, 137,038 in 2020, and 196,634 in 2021. The number of UK trademark applications has tripled between 2016 and 2021. In percentage terms, this represents a growth of 200%. 135,475 EU trademark applications were filed in 2016, 177,237 in 2020, and 197,938 in 2021. So the volume of EU trademark applications has also increased over the same period by 62,463, or 46% in percentage terms. The record volume of UK trademark applications filed in 2021 was only 1,304 fewer than the number of EU trademark applications. This is not surprising, as the UK remains an important market for many international businesses. Many businesses now file simultaneous UK and EU trademark applications to obtain protection in the UK and the EU. UK applicants are a key driver in the increase in the volume of UK trademark applications being filed. Growth from Chinese and US applicants has also increased UK filing figures.
Thank you, Jason. This graph shows the month-by-month trend since the beginning of 2018. What we know and can see from this is that there was already steady underlying growth in UK trademark filings. Until 2020, the UK system was used by companies operating only or primarily in the UK and for brands intended primarily for the UK market. The EU system was used by larger companies with products and brands in multiple EU countries. From 1st January 2021, the UK system has to be used by both. Trademark applications that might previously might previously have been filed in the UK only, now needed to be filed in the UK and EU. The trend already started in 2020 as trademark owners sought to secure their position in the UK early. From Q2 of 2021 onwards, there is a noticeable increase in businesses as businesses realise that Brexit would definitely happen. From October 2020, there was no possibility that pending EU trademarks would be registered before 31st December, thus qualifying for a cloned right. And so it was already necessary to make a duplicate application in the UK. So there is another increase in Q4 until the end of 2020. Since 1st January 2021, the increase has been greater still. In March 2021, UK trademark filings were higher than EU trademark filings for the first time. Since March 2021, there was a noticeable slowdown, but another predicted spike of filings occurred in September 2021. This was the cut-off date for filing applications claiming back the priority date of EU trademarks, which were pending at the end of the Brexit transition period. Filing levels by the end of 2021 remained at significantly higher levels compared to before the Brexit vote in 2016.
The database used to generate this data has included cloned rights. As you can see from the graph, UK-based applicants are by far the biggest filers of UK trademarks. In the first 4 months of 2021, UK applicants filed 39,153 UK trademark applications, an increase of 14,824, or 61%, over the first 4 months of 2020. Filing rates slowed down later in the year, but there was still almost a 10% increase in the volume of applications filed by UK-based applicants in 2021. The volume of UK trademark applications filed on behalf of Japanese applicants has shown a trend of slow and steady growth from 1,528 applications in 2011 to 3,859 applications in 2021. There has been a significant increase in the volume of UK trademark applications filed by Chinese applicants. This is unsurprising, as there has been a significant increase in applications filed by Chinese applicants at major registries around the world. The years 2020 and 2021 have demonstrated rapid growth in applications originating from Chinese applicants. For example, in October 2020, Chinese applicants surpassed US businesses to become the largest source of US trademark applications at the USPTO. This prompted the USPTO to publish a report into the impact that filing may have on the US trademark register. The USPTO claimed that the applications originating from China lack value and clutter the register. According to the report, the significant increase in applications filed by Chinese applicants is partly fueled by Chinese government subsidy measures. The financial incentives often exceed the cost of registering a trademark, which may incentivize Chinese applicants to file overseas applications even if they do not have an intention to use the mark. This may explain why we have seen many UK and EU trademark oppositions go undefended when the applicant is a Chinese company or individual. We understand that the Chinese government plans to end trademark subsidies. Interestingly, Chinese applicants overtook German applicants in 2020 as the biggest filers of EU trademark applications. This trend has continued into 2021, as Chinese applicants filed 34,377 applications compared to the 27,571 applications from Germany. The top 10 filers in 2021 were China with 34,377 applications, Germany in second with 27,571, and then we go through the US, Italy, Spain, France, the UK, Poland, Netherlands, and Austria. In total, filings from the top 10 countries amounted to 72.5% of the total EU trademark applications filed in 2021. As many of you may know, there is no use requirements in the EU, and specifications can be drafted very broadly. So there is a genuine risk that the EU trademark register will become cluttered. The EU IPO published a report in 2020 that looks at the evolution of EU trademark applications and registered community designs filed by Chinese applicants. The EU IPO report concludes that the office will closely monitor the evolution of filing volumes from China to properly adjust strategies and capabilities. Japanese applicants typically file around 5% of the total number of EU trademark applications. The number of EU trademark applications originating from the UK in 2021 has shown a decline from the 2020 figures. This is unsurprising. Many UK applicants filed EU trademark applications before Brexit, as it was a cost-effective way to obtain protection in the UK and the other 27 member states of the EU, even if the short-term focus was on the domestic UK market. Now UK businesses with a short-term focus on the UK market may simply opt to file in the UK and revisit EU protection at a later date. Now we turn to oppositions. The UK IPO received 6,793 oppositions in 2021, compared to the 3,602 oppositions filed in 2020. This constitutes an increase of slightly over 88% in the volume of oppositions filed between the 2 years. Many prospective opponents in the UK first file a notice of threatened opposition before commencing formal opposition proceedings. In 2021, the UK IPO received 13,948 notices of threatened opposition. Only around 49% of the notices of threatened opposition were followed by actual oppositions. This is compared to around the 60% of notices of oppositions that were filed in 2020, which followed by formal opposition proceedings. This suggests that there has been a significant increase in the volume of disputes that are being settled before the formal opposition is filed. Overall, the trend in the increase in the volume of oppositions and notices of threatened opposition is not surprising, given the significant increase in the number of UK trademark applications that are now being filed. As many of you will know, the UK IPO does not examine on relative grounds. It will not object to an application on the basis of earlier rights. However, it does conduct a search of the register during the examination stage, and it will notify owners of earlier marks that are considered similar to the mark applied for, to give the owner of the earlier mark an opportunity to oppose the application. The UK IPO has informed us that an average of 2.6 notifications were issued per application prior to January 2021. The average number of notifications per application rose to 3.7 from January 2021. There has also been a marked increase in EU oppositions between 2020 and 2021.
Thank you, Jason. So, in conclusion, we have seen a significant increase in UK trademark applications and over 1.5 million cloned UK registrations on 1st January 2021, plus owners of UK trademark applications that were pending at the end of the transition period had until 30th September 2021 to refile in the UK. The corresponding UK trademark application was then treated as a cloned right. There has also been a significant increase in UK trademarks generally. The UK is still an important market for many businesses. The UK and EU trademark registers are becoming cluttered as a result of the increase in filings. The UK trademark register has become more cluttered due to the cloning of EU trademarks. Clearance searches are now more complicated and important due to the increase in UK trademark registrations and applications. It is important to note that standard UK trademark searches no longer automatically include EU trademarks. EU trademark searches will need to be added to a UK clearance search if required. There is an increased opposition risk due to the increase in the number of UK trademark registrations. The UK IPO notifies owners of earlier marks when a similar mark is published. The UK IPO will give the applicant an opportunity to amend the specification applied for before the owner of the early mark is notified. We generally recommend waiting to see whether the owner of the earlier mark takes issue before amending the specification. This is to avoid unnecessarily amending the specification when it is not clear whether the owner of the earlier mark will take issue. There may be some instances where an amendment may be appropriate. The increased opposition risk also illustrates the importance of conducting trademark searches prior to filing. Some of the cloned rights may be vulnerable to revocation. It is important to note that use made in the EU prior to the end of the transition period can be taken into account. Where there is no use, the UK revocation procedure can be relatively cost-effective and quick. Unlike in the EU, a registration will be cancelled if the register proprietor does not file a defence. As we discuss in the next talk, there are different opposition procedures and grounds. in the UK and EU. A notable difference is that it is possible to oppose on absolute grounds in the UK, but not in the EU. It is thus possible to challenge an application on the grounds of bad faith and non-distinctiveness in a UK opposition. Clients may wish to adopt specific strategies and tactics for dealing with Chinese counterparties. A distinction should be drawn between legitimate Chinese applicants and imitation brands. This will have a bearing on the overall strategy and tactics. There may be grounds to challenge a UK application filed by a Chinese applicant on the basis of bad faith. For example, if it can be shown that the applicant has no intention to use the mark for some or all of the goods and services applied for. Prospective opponents may wish to file an opposition without filing a notice of threatened opposition. For example, if it does not look like the applicant is likely to engage in negotiations. A UK application will be refused if an opposition is not defended. We've also seen an increase in Chinese applicants appointing UK representatives that are not based in the UK. The overseas representative sets up a PO box address in the UK or nominates the home address of a friend or a relative in the UK. This may circumvent the UK address for service rules. This is something that is being looked at by our regulatory body and by SITMA. SEPA and UK firms may lobby the UK IPO to crack down on this practice. That concludes the first presentation, and there will now be a short break. Thank you for listening.
Hello everyone, and welcome to this part of the session. And I will be briefly speaking about the differences between the UK and the EU intellectual property offices. Whilst the case law and tests applied by the UK IPO and the EU IPO to decide the outcome of trademark oppositions are effectively the same for now, there are some important differences in interpretation and procedure. We will briefly look at UK and EU opposition trends involving Japanese companies. And finally, we will discuss opposition tactics where a client discovers that an applicant has filed a new UK and an EU-wide trademark in tandem. This slide gives an overview of the UK opposition procedure. The starting point for UK oppositions is that the trademark is published in the Trademarks Journal. The date of publication is important because the opposition deadline is 2 months from this date. And as can be seen in the yellow box to the top right of the slide, it is possible to extend the opposition deadline by 1 further month by filing a notice of threatened opposition. Taking this step is often looked upon favourably by the UK opposition division when an award of costs is made. The next step is to file a full notice of opposition and a mandatory statement of grounds. The opposition division will review all of the papers and check that the opposition meets the tribunal's admissibility requirements. The applicant is set a deadline by the tribunal to file a defence and counterstatement. And if the applicant or their representative fails to submit a defence and counterstatement, the application is generally deemed to be withdrawn for all of the goods and services that have been objected to. The applicant's counterstatement must admit, deny with explanation, or indicate that proof is required of any of the grounds set out by the opponent in its statement of grounds. If the defence and counterstatement does not meet the strict procedural requirements, it will be rejected by the hearing officer. Alternatively, and as can be seen from the green boxes on the left side of the slide, if both parties agree, it is possible to request by the same defence and counterstatement deadline for the parties to enter into a cooling off period in order to negotiate settlement. The opponent can opt out of the cooling off period at any time by filing form TM9T. The applicant can opt out of the cooling off period at any time by filing its defence and counterstatement. If settlement discussions are still ongoing after 18 months, it is possible to file a request to suspend the proceedings for 3 months at a time. The parties will need to show what has been done in their negotiations in the period prior to the request, the dates upon which the actions were taken, and the nature of the actions. Moving back to the centre of the flow diagram, once the applicant's defence and counter-statement is filed, the proceedings will move to the evidence rounds. The opponent is set a deadline to file evidence first. This may include a proof of use evidence or reputation evidence. The applicant then has 2 months from receipt of the opponent's evidence to file evidence in response. The opponent is then permitted 1 further month to indicate whether they wish to file evidence in reply. A quick word on extensions of time. It is possible for either party to request an extension of time to file evidence and submissions. However, the request is not automatically granted. Once the evidence rounds are complete, the tribunal will invite the parties to request a hearing. Alternatively, final written arguments can be made and the tribunal will make a decision on the papers. Turning to the EU opposition procedure, following acceptance past the examination stage, the EU trademark will be published in Part A of the European Union Trademarks Bulletin, and third parties will have 3 months from the date of publication to file a notice of opposition. Following this, the opposition division will release a timetable for the proceedings. There is an initial 2-month cooling off period, and it is possible to extend the cooling off period by a further 22 months upon joint agreement by the parties. So the total cooling off period available is 24 months. It is possible for either party to opt out of the cooling off period, provided that the request to opt out is not made during the last month before the commencement of the adversarial proceedings. A 6-month suspension of the proceedings is granted automatically upon joint request after the expiry of the cooling off period. The suspension can be extended up to a maximum of 2 years. And if there is no extension to the cooling off period, the adversarial stage begins. The first step in the adversarial proceedings is the opponent files further facts, evidence and arguments in support of the opposition first. This may include evidence that the sign relied upon by the opponent has a reputation or has an enhanced distinctive character. Following this, the applicant has an opportunity to file observations in reply within 2 months. And this deadline is fixed by the opposition division in the timetable. So the deadline does not run from receipt of the opponent's evidence. If the applicant files observations in reply, the opponent has the option to file a counter-reply, again within a fixed deadline, that is 2 months from the applicant's previous deadline. In some cases, the EU Opposition Division may grant additional rounds of observations. Extensions of time are possible, and the EU Opposition Division will grant the first extension of time as of right. Extensions of time after the first request require reasons. So let's have a look at the main differences between opposition proceedings in the UK and the EU. The UK IPO opposition window is shorter, namely 2 months, in contrast with the EU IPO opposition period of 3 months. It is mandatory to file a statement or explanation of grounds in UK opposition proceedings, whereas all that is required in EU IPO opposition proceedings is the bare notice of opposition. If the applicant fails to file a defence and counter-statement in UK opposition proceedings, the application may be deemed abandoned except for in exceptional circumstances. In EU opposition proceedings, the applicant does not need to respond at all, and the matter may still go all the way to a decision. Cooling off periods in UK opposition proceedings are shorter than in EU opposition proceedings. Generally, EU IPO procedural deadlines are longer and allow more time for parties to agree on a settlement. For example, the cooling off periods and suspension periods are longer. In EU IPO proceedings, there is also no requirement for the applicant to submit a defence to the opposition to prevent a decision being issued against them by default. As a general rule, UK opposition deadlines are shorter. The tribunal has more onerous requirements when it comes to granting extensions and suspensions. And there is less time built into the timetable for parties to conduct settlement negotiations than in EU IPO proceedings. There is no automatic right to extend deadlines in the UK, and strict criteria must be met that outlines what has been done to date, what is left to do, and how long is necessary to meet the extended deadline requested. In contrast, in the EU, the first extension of 2 months is provided as of right. Suspensions are possible in both the EU and the UK proceedings with reasons. However, it can be difficult to obtain a suspension for more than 3 months at a time in UK IPO proceedings. In EU IPO proceedings, suspensions are available in 6-month increments up to a total of 2 years. In UK opposition proceedings, Case management conferences are regularly used to discuss procedural points. In EU IPO opposition proceedings, matters are generally dealt with on the papers. The UK IPO has strict rules for the format of evidence, requiring that it must be filed by way of a witness statement, affidavit, or statutory declaration. This is not a requirement at the EU IPO, and evidence can be integrated into the body of the arguments. At the end of the proceedings, the UK IPO allows parties to request the option of a hearing where a decision is taken, whereas the EU IPO requires written arguments. There are also some interesting differences between the UK IPO and the EU IPO's practices after a decision is made in the opposition proceedings, which we will touch on in a moment. Suspensions are possible in both the EU and the UK with reasons. In both cases, consent is required from both parties. Owing to the UK IPO's policy to conclude proceedings quickly, obtaining permission for the request can be more challenging. It can be difficult to obtain suspensions for more than 3 months at a time in UK IPO proceedings. In EU IPO proceedings, suspensions are available in 6 months increments up to a total of 2 years. Case management conferences are available in the UK in relation to procedural points, such as confidentiality requests for evidence, and also extensions of time. Case management conferences are not available in EU IPO proceedings. For example, UK cost awards are awarded by reference to a scale of costs, and the tribunal has a wide discretion and can award off-scale costs, particularly if a party has acted unreasonably in the proceedings. So this is one of the differences between UK IPO and EU IPO practices after a decision is made, I should add. Failure to pay a cost award in the UK can result in details of the failure to comply being published on the UK IPO's website, and this can encourage the losing party to pay the cost award. In contrast, there is no such mechanism in EU opposition proceedings. Appeals are possible in UK proceedings, either to the appointed person or to the High Court. From the High Court, an appeal would go to the Court of Appeal and appeal from there onto the Supreme Court. In EU IPO proceedings, appeals go to the Board of Appeal, then to the General Court, and finally to the Court of Justice of the European Union. In the event that an opposition is successful in the UK and the trademark is refused in its entirety, there is no scope to convert the UK application. In contrast, if an opposition is successful in EU IPO proceedings and the earlier right holder has relied upon a national trademark registration within an EU member state, as opposed to an EU-wide trademark, it may be possible to convert the EU-wide trademark application into national applications in the remaining territories where the opponent has not successfully relied upon an earlier right in the opposition. So how does this impact companies in Japan? This slide shows the number of UK and EU oppositions involving Japanese companies filed each year since 2013. We can see that the number of UK oppositions involving Japanese companies increased significantly in 2021 compared to the previous year. And this is not surprising, given that the overall volume of UK applications filed in 2021 was a lot higher than in 2020. The volume of EU oppositions involving Japanese clients decreased in 2021 compared to 2020. This goes against the general trend, which saw an increase in EU oppositions in 2021 compared to 2020. So often clients find themselves in a position where they are having to object to both a UK and an EU-wide trademark application by the same applicant at around the same time. Sometimes a client may discover that a third party has a pending EU and UK trademark application for identical protection. And in these instances, there are benefits and cost savings to instructing a single firm to handle both. Some examples of cost savings include coordinated strategies and negotiations with the other side and putting forward coordinated arguments. Sometimes it may be possible to save on cost by focusing on one territory to file an opposition and using this as leverage to force the withdrawal or amendment against both marks. Trademark owners should also consider the relative strength of their position in each territory and whether the procedure is more or less favourable, particularly where the opponent is alleging that they have a reputation in a given territory, or where their earlier rights are more than 5 years old and are subject to proof of use requirements. Marks & Clark's UK and Luxembourg offices work together on teams from the outset to ensure that there is an integrated and collaborative approach. We also use a digital workflow platform which integrates the management of cases across the UK and the EU offices. Thank you for listening, and we will now take a short break before moving on to the third session.
Hello, everyone, and thank you again for joining us for this webinar. As introduced before, my name is Eric Rook, and I am a trademark attorney at the Luxembourg office for Marks and Clark. I am joining Kirsten Gilbert in presenting the third and final topic of this webinar. Together, we will briefly discuss the reasons for engaging with customs measures, review customs measures available in the UK and the EU, and provide practical recommendations. In this part of the webinar, we will ask and answer the questions. Why should brand owners be interested in customs enforcement? How did the customs AFA regime operate before Brexit? What has changed after Brexit? There are two main reasons for engaging with customs measures. Firstly, it stops lower quality counterfeits from entering the market and causing reputational damage, as well as a potential loss of sales. Secondly, it is more cost-effective than litigation once the goods have entered the market. To put the matter in perspective, we will first look at the recent trends relating to customs enforcement and seizures of counterfeits. In the year 2019, there were 90,000 seizures of goods by EU customs. 41 million individual items were seized with a total retail value of 760 million euros. Over 60% of counterfeits originated from China and Pakistan. 21% of the seized goods were cigarettes, 14% packaging material, 10% toys, 4% clothes, and 23% other goods, including high quantities of matches. Obviously, with products like matches, if counterfeit products do not meet the safety requirements met by genuine products, then the safety concerns could be significant for a product like this. The same can be said of counterfeit toys. The chance that significant reputational harm can easily be seen. In the year 2020, 70,000 seizures resulted in 27 million individual items seized. The total retail value of the goods was 778 million euros. Of the goods seized, the largest categories were packaging material, mainly for perfumes and juices at 23%, foodstuff at 17%, and clothing at almost 10%. The reason for the high volume of packaging material is that counterfeiters often import non-branded goods and then attempt to separately import packaging that would allow them to pass the counterfeits off as genuine products. This aspect highlights the importance of varied IP protection and relying on trademarks, registered designs, and copyright in customs enforcement to tackle different infringing goods. It is important to note that out of the number of seizures made, more than 98% in 2019, and more than 97% in 2020 were made based on an existing application for action, and less than 2% and 3% of cases in these years were raised on an ex officio basis, that is, initiated by customs authorities without an AFA. In the UK, the Border Force is the entity responsible for customs enforcement. During the period April 2020 till March 2021, a total number of 1,905 seizures were carried out. The end of the year in 2020 and the beginning of the year in 2021 saw a rise in the number of items seized by Border Force. In February 2021, particularly large shipments of items were seized. The overall quantities of items seized demonstrate an upward trend. This may be because of uncertainty surrounding Brexit. Counterfeiters may be attempting to exploit the United Kingdom's exit from the EU to try to increase their activity in the UK directly. Future statistics will allow us to comment further on this. Data from the EU has demonstrated that there is a continued interest for counterfeiters to attempt to bring counterfeit goods to the market. I will now hand over to Kirsten, who will review the customs measures available to rights holders to prevent counterfeiting activities.
Thank you, Eric. The main tool for customs enforcement in the EU and the UK has been the application for action known as an AFA. An AFA is basically a request to border control officers to be on the lookout for counterfeit products arriving into their country. If suspect goods are found, they are seized until the question of their authenticity has been resolved. Across the EU, it is possible to apply for an AFA either on a national or on a union-wide basis, depending on your preference and on the intellectual property rights on which the application is based. If you only have a national right, then you can only apply on a national basis. A union-wide AFA, when granted, will cover the whole of the EU. There is no official fee for applying for an AFA. However, the owner of the IP rights will need to give an undertaking to pay certain costs in some situations. Such circumstances could arise when seized goods are stored for an extended period of time while legal proceedings are contemplated. Since September 2020, in order to submit an AFA, the owners of IP rights need to hold a valid EORI, or Economic Operators Registration and Identification number. The AFA can be requested for up to a year and can be renewed annually. There are simplified procedures available for sending information to customs authorities when the application is made and even after it has been granted. The Intellectual Property Enforcement Portal makes it easier for owners of rights and their representatives to not only submit AFAs online, but also to submit relevant materials about their IP rights and how to help customs identify genuine products. Such information can be shared among the customs authorities of the member states to help with seizures. What is not covered? It is important to note that in addition to not covering the UK, the EU-wide AFA does not extend to other members of the EEA, such as Iceland, Liechtenstein, or Norway, or to third countries such as Switzerland. As mentioned briefly before, the customs authorities of member states can make seizures on an ex officio basis. This happens when they believe that the goods may be counterfeits and infringing a third party's IP rights, but there is no pre-existing AFA in place. In such cases, the customs authorities will contact the representatives of the owners of IP rights, or where no representatives are listed, the owners of the IP rights directly. The rights owner will then have an opportunity to file an AFA, and the seizure will proceed as normal. So what does happen when customs find suspected counterfeit goods? When customs find suspicious goods, they will notify the rights holder as well as the importer. Customs authorities will provide the rights holder with information on the shipment and a sample of the goods. This is to enable the rights holder to identify if the goods are genuine or counterfeit. The rights holder will have a 10-day extendable deadline to confirm the status of the goods. Just note that if the goods in question are perishable, the deadline is 3 days. If the rights holder confirms that the goods are counterfeit, then under the streamlined procedures, customs will destroy the goods if the importer does not object to the destruction or does not respond at all within the relevant time period. If the importer objects to the destruction of goods which have been identified by the rights holder as counterfeit, customs will release the goods unless the rights holder can show that they have issued legal proceedings. If legal proceedings have been issued, then the goods will be seized until the end of the legal proceedings. The costs associated with holding the goods will be the responsibility of the rights holder. It is important to bear this in mind if you are looking at a very large shipment, as some legal proceedings can take many months, sometimes years, to be resolved. The information setting out the details of the detention, the name and address of the importer and the consignee, can be used by the rights holder to determine that the goods are counterfeit, to contact any of the interested parties to seek their consent to the abandonment of the goods, or to initiate infringement proceedings. The information can also be used to seek compensation and to support criminal proceedings. However, rights holders are still prohibited from using the information for more general investigative purposes. Following Brexit, the UK is no longer part of the EU AFA process, and it now has its own AFA regime. EU AFAs no longer cover the UK, although it is still possible to indicate Northern Ireland in respect of certain protected geographical indications. However, the procedure in relation to the UK is the same as for the EU. All that you have to do is make a separate application to cover the UK, and then you will maintain the complete protection you would previously have had with the EU-wide AFA. Our recommendation is to file an AFA in the UK in addition to in the EU. An important point to note is that following Brexit, the position regarding parallel imports has changed. Goods placed on the market in the UK will no longer be considered exhausted in the EEA, but the opposite is the case for goods placed on the market in the EEA. This creates the possibility for rights holders to prevent parallel imports into the EEA of goods placed on the market in the UK. If you are aware of goods which are not counterfeit, but which would infringe your intellectual property rights, such as grey market goods or parallel imports, which are due to arrive in the UK at a specified time and place, you can give notice in writing to customs and ask that the goods be treated as prohibited goods. This only applies to infringing goods arriving from outside the EEA. It is highly likely that once notified, customs will seize the goods. The new UK customs recordal form will have to be filed online. Rights holders or their representatives are required to first be registered with Her Majesty's Revenue and Customs and will be required to possess an EORI number. As mentioned before, in the EU, it is possible to manage protectable rights and custom actions more effectively through the Intellectual Property Enforcement Portal. Information in the portal is fully searchable by any of the relevant organisations across Europe. The portal also translates the information into the many languages of the EU. Access to the best quality information in as short a time as possible is often vital for effective seizures of counterfeit goods. In terms of practical recommendations, rights holders would do well to ensure that their IP rights are appropriately protected and that they have a good overview of such rights, that materials and guidelines for identifying genuine articles from counterfeits have already been registered with the Intellectual Property Enforcement Portal, or that these are at least readily available. That there is sufficient in-house awareness of the process of dealing with notifications. These cases can be very time sensitive, and so a good understanding and effective internal processes are important. We are more than happy to offer training to assist with this aspect. It is also possible to partner with other entities to take joint action and to improve brand protection. There are anti-counterfeiting groups in the UK and the EU. Sometimes rights holders also cooperate with their competitors against counterfeiters who target multiple companies in their activities. Good contacts with such organisations can help the enforcement process. Also, such groups are able to help arrange training sessions with custom officers where rights holders or their representatives can train custom officers to recognize counterfeit goods. In our experience, such sessions are likely to increase the chances of customs officers identifying and seizing counterfeit goods. As we have discussed, engaging with the customs regimes in the UK and the EU is an overall cost-effective way of tackling counterfeit goods and importers of such goods. There are no big differences between the UK and the EU AFA process, but a separate application is required for the UK. It is better not to rely only on the initiative of the customs authorities, and it is better to submit an AFA when counterfeits are suspected. A good understanding of the customs regime and having an anti-counterfeiting strategy in place will help to fight unauthorized third parties and counterfeits more effectively. That concludes the presentations. We will now have a short break before the question and answer session. Thank you for listening.
We would now like to start the Q&A session. So I'm going to start with a question for Kirsten.
では、質疑応答の時間となります。
Could customs registration of trademarks help prevent EU to UK and UK to EU parallel imports?
この税関の措置、アファによって、EU から UK、またUK から EU の方への不正な輸入を止めることは、有効に止めることは可能なんでしょうか。
Thank you for that question. Customs recordals using the AFA system I described today will not seize parallel imports.
はい、カスタムのポータルなんですけれども、今日これを AFA と絡めてお話をしましたけれども、並行輸入の方は見ていません。
However, as I mentioned, if you are aware of a shipment of parallel imports due to arrive in the UK, then you can notify customs of the details of the shipment, and if they can locate it, they will seize the goods.
はい、しかし、このUK に、英国の方に入ってくる並行輸入のこの荷物がですね、分かっていれば、それを税関に知らせまして、その情報の詳細ですね、を提供することができます。
So the main difference is that you cannot ask customs to be on the lookout for parallel imports. You have to notify them about specific shipments.
はい。で、それによって、税関は押収することができるんです。ここで、大切なのは、税関が自動的に、それを監視して、取り締まるということではなくって、その通知をしなければならない、ということです。
I should also just mention, as I did briefly, that the position with parallel imports in the UK has changed since Brexit.
そして簡単に触れましたけれども、ブレクジット後、英国での並行輸入のこの位置づけは変わりました。
So goods placed on the UK market by or with the consent of the right holder are no longer considered exhausted in the EEA.
はい。で、UK マーケット、英国のマーケットに入ってあるその物品はですね、照準がありません。英国でのものは照準はされません。
So this means that businesses exporting IP protected goods from the UK to the EEA will need to get consent from the rights holder in the EEA.
ですので、これは英国から EEA への輸入ということなんですけれども、ですので、ここで、その輸出をする方ですね、これは権利を持っている人ときちんと合意をしておかなければ問題が生じてしまいます。
Thank you.
ありがとうございます。
Thank you, Kirsten.
クリステン、ありがとうございました。
Next question is for Tom.
次の質問はトムに対する質問です。
In both the UK and EU TM, the number of applications filed by Chinese companies is increasing, many of which includes imitation trademarks.
はい。中国のからのですね、申請者、これは英国、そして、EU、どちらもそうなんですけれども、模造品による申請が増えてきているという話がありました。
Is there a high percentage of trademarks that are filed, not actually expected to be used, in anticipation of distant future use, rather than trademarks that are actually used or will be used in the near future.
で、実際に使用されている、もしくは近い将来使用予定のある商標ではなくって、遠い将来の使用を見越して出願される、つまり実際には使用されることはないような商標の割合は高いのでしょうか。またその傾向は中国以外の企業に比べて高いのでしょうか。
Also, is that tendency higher than that of companies in other countries other than China?
他国の企業に比べて高いのかというのが2点目です。
Thank you. A good question.
ありがとうございます。良い質問です。
The increase in trademark applications by Chinese companies is driven by China's Belt and Road Initiative.
はい、実際に、中国の企業ですね、からの商標の申請は非常に、増えています。
This is a plan to develop trade in strategic countries connecting China and the West.
はい、ですのが、ここで、戦略が大切なわけです。トレードの商標に対する戦略、中国とそれと西側諸国との、そのビジネスにおいてですね、商標の戦略が大切になってきます。
This is a long-term plan, and the Chinese government provided funding to companies to secure IP rights in those countries.
はい、中国政府が資金を提供して、それらの国の中での IP 知財権を保護するようにしています。
For legitimate Chinese brand owners, this provides an opportunity to protect their trademarks in countries where they do not yet trade.
で、ですので、合法的な中国の企業に関しては、まだ、商標権を取っていない、国で、商標権を取って、そしてその物品の保護をする、ということが、その合法的な企業にとってはプラスとなります。
For those companies, it is a long-term or distant future intention to use their trademarks.
はい。で、将来、ずっと将来ですね、にそれを使うというようなことで、取るわけです。
In my experience, China takes a long-term view and plans accordingly.
ですので、私の経験に基づきますと、中国はかなり長期の見通しを立てて、このような計画、戦術を取ってきているということです。
So legitimate Chinese companies also make long-term plans.
はい。先ほど申しましたけれども、合法的な中国の企業もまた長期の戦略を取っております。
I would say that this tendency is higher than, for example, UK business, which tends to look for short-term or medium-term profit.
はい。で、一方、例えば英国なんですけれども、そちらの傾向と比べますと、英国は短期、もしくは中期の計画や見通しでビジネスを行っている商標権に対する戦略も取ってきているということです。中国は長期戦略でやってきているということですね。
Thank you.
ありがとうございます。
Thank you, Tom. The next question is for Eve.
次は、ありがとうございました。次は、イブへの質問になります。
If the applicant does not respond at all and the application is rejected, is there any possibility still that the applicant can file an appeal against the rejection?
はい。もし、申請者が何の応対もせずに、それが取り下げられてしまった、申請が取り下げられてしまったということが一旦あったとしても、その同じ案件を上告していくことは可能なんでしょうか。
One of my clients won in the UK opposition case, i.e., the application was deemed rejected some weeks ago.
私のクライアントの一人は、英国の異議申し立て事件で勝った、つまり数週間前に、出願が拒絶されたとみなされましたが、
But I wonder if the applicant can still revive because we fight with the same applicant around the world.
出願人はしかしそれでも再度復活できるのでしょうか。
Thank you for your question.
ご質問ありがとうございます。
If the applicant does not file a defence and counter statement by the stipulated deadline,
はい、もし、この出願人が決められている期限までにですね、応答しなかった場合ですけれども、
the UK Opposition Division will write to the applicant and give them a final chance to respond.
英国の異議申し立て部は手紙を出してですね、その本当に応答しないのかどうかということを、知らせます。もう一度チャンスを与えるということです。
The applicant will need to give full written reasons as to why the defence and counter statement deadline was not met.
で、その場合に、申請者はなぜ、決められた期限までに、その応答しなかったのかという細かくその理由を書面で書いて提出することが、必要になります。
The reasons must be in the form of a witness statement and they must attend a hearing.
そしてその理由は十分な隅から隅までカバーをするような理由で、あるべきであり、また校長ですね、審理が行われます。
If no response is received, the registry will proceed to deem the application abandoned at that stage.
はい、それでも応答がない場合には、この申請は無効となり棄却されます。
The position is different if the applicant does file a defence and counter statement, but does not respond after that point in the evidence and arguments rounds.
しかし、この反対陳述とか弁護の申請をしているけれども、その後のステップとなります証拠とかの段階で、反応してこなかったという時にはまた扱いは違ってきます。
If the opponent wins, the applicant has the option to appeal the decision either to the appointed person or to the High Court.
はい。で、もし、この上告が可能になりましたら、例えばその決められた人、もしくは高等裁判所に、することが可能となります。申請者の方の意見が通ったらということですけれども、上告が可能となります。
The notice of appeal must be filed within 28 days.
しかし、上告は28日以内に行われなければなりません。
And if no appeal is lodged within that time, then the decision will be implemented.
もし、その28日以内に上告の申請がなければ、審理がなされ、決定がなされます。
Thank you.
ありがとうございました。
Thank you, Eve.
すみません。今の質問ですけれども、最初のところ、私の通訳がもし、正しく言えていなかったら、困りますので、すみません。ちょっと確認だけさせてください。この今の質問は、出願人が全く応答せず拒絶された場合、出願人が拒絶査定不服審判を請求する可能性はあるのでしょうかという質問に対してでありました。Sorry to interrupt you. Please go ahead.
Thank you. The next question is for Eric. And this is a question about opposition in EU.
次はエリックに対する質問です。これはEU での異議申し立てに関するものです。
I understood that there is no need for the applicant to submit a defense against the notice of opposition and the opposition procedures will still proceed.
はい。申請者は、EU の場合にはですね、異議申し立ての通知をしなくても、審理は進んでいくということは理解しております。
In the meantime, will the fact itself that the applicant did not submit any defense be taken against the applicant in the final decision?
はい。しかし、この事実として、申請者が全くこの弁護の申請をしなかった。そして、最終的な審理に到達していくということなんですけれども。
Thank you very much for the question.
質問ありがとうございます。すみません。審理ではなく審決でした。ありがとうございました。
In the EU opposition procedure, there is no formal requirement on the applicant to submit a defense or observation, unlike in the UK.
英国と違って EU の場合は、この弁護とか、それから所見などの申請をする必要はありません。異議申し立てに対して。
Not filing observations may weaken the applicant's prospects of success if the opponent is allowed to make their argument unchallenged.
はい。でも、これがうまくいくのは、この相手方がですね、それに対して敵対的な対抗姿勢を取らないときです。
However, the EUIPO's opposition division will make their decision based on the grounds and arguments filed on an objective basis.
はい。しかし、この EU の知財庁、異議申し立て部のこの審決というのは、この異議申し立てをされたアーギュメントですね、主張をきちんと出された主張をベースにして、審決はなされます。
This means that an opposition might not be successful
つまり、どういうことかと言いますと、異議申し立てをした人は、そのような場合には成功しないということです。
if the basis for opposition is not satisfied in the assessment of the EUIPO's opposition division.
はい。もし、この異議申し立て者の方の行動が、十分ではなく、そして、EU の知財庁を、説得することができないような対抗の仕方であると、そのような結果となってしまいます。
For example, if likelihood of confusion is the ground relied upon,
はい。例えばですけれども、その結論は自由によります。理由がどのようなものなのかというのが大きく左右するということです。
But in the EU-IPO's assessment, there is no likelihood of confusion.
しかし、EU の知財庁ではそのようなことはありません。
Because the marks are different or because of differences between the goods or services.
なぜならば物品やサービスが違うからです。
Such an opposition may not succeed even if no observation or defense has been filed by the applicant.
もし申請者から書簡やそれから弁護の申請がなかったとしても、異議申し立て者は成功することがないでしょう。
Thank you.
ありがとうございます。
Thank you, Eric. I think with that, we will end the Q&A session.
ごめんなさい。
So, 本日はお忙しい中、ウェビナーにご参加いただきありがとうございました。Q&A ではお答えできなかったご質問、それ以外で何か他にご質問などございましたら、講師もしくは弊社のクライアントサポートエグゼクティブの近藤にメールをいただければ幸いです。ウェビナーの資料と一緒にメールアドレスもお送り申し上げます。これにて本ウェビナーを閉会させていただきます。
Thank you very much for your participation today. And we will conclude a question and answer session together with the webinar itself. So our Kondo will, if you have any questions, please feel free to contact us. The Kondo will check out all of your questions. And also the document will be sent to you together with the contact addresses. Thank you very much.